Welcome to Constitutional Law Part 3. In this section we're going to talk about substantive due process and equal protection. In this discussion we're going to talk about standards of review. Just going to get those out of the way right now. Looking at the standard of review for strict scrutiny, the law must be the least restrictive means to achieve a compelling government interest. Compelling government interest, there's no precise definition, is generally understood to be something that is necessary or crucial, such as national security or preserving public health and or safety. Burden in this case is on the government. So when the law is subject to strict scrutiny, the burden is on the government, and the government must defend the interest stated when the law was enacted. You can't come up with a new one. This is generally hard to meet strict scrutiny, and laws faced with this are generally struck down. Next we have intermediate scrutiny, and this standard of review only applies to equal protection. Intermediate scrutiny, for a law to be valid, the law must be substantially related to an important government interest. And again, that applies only to equal protection issues. In intermediate scrutiny, as in strict scrutiny, the burden is on the government, and they must defend the interest stated when enacted. The final standard of review is the rational basis test. A law meets this test if it's rationally related to a legitimate state interest. Here, the law is initially presumed valid, and the burden is on the challenger of the law. Laws subject to rational basis standard of review are generally upheld. Again, this section covers substantive due process and equal protection. Looking at substantive due process states generally that laws should be reasonable and not arbitrary. An example might be the good moral character standard at the Board of Law Examiners that might be considered arbitrary. Now, a government action under substantive due process that infringes upon a fundamental right is subject to strict scrutiny. If the interest infringed is not a fundamental right, then the law is only subject to rational basis review. Fundamental rights under substantive due process are rights under the Bill of Rights or others provided by the court. So Bill of Rights, the right to vote, travel, the right to privacy, which includes marriage, sexual relations, abortions, child rearing. When looking at substantive due process and the fundamental rights in regards to abortion, you apply the undue burden test. The purpose or effect of the state law places substantial obstacles in the way of seeking an abortion. Prior to viability, it might be or it might not pass the undue burden test. Moving on to equal protection. Equal protection is found in the 14th Amendment, applies to the states. No state shall deny any person within its jurisdiction equal protection of the laws. There is no federal equal protection. However, the Supreme Court has determined that the 14th applies to the federal government through the 5th Amendment, and that was from Bolling, B-O-L-L-I-N-G. Under substantive due process, when looking at we're only looking at fundamental rights affected. If the law affects the fundamental rights, that substantive due process must be addressed by those standards of review. Here, under equal protection, we look to classification of people and or the type of right concerned. So equal protection includes the rights, but also classifications of people. As with substantive due process, where a fundamental right is affected, you apply strict scrutiny. However, where a suspect classification is also affected or separately affected, you apply strict scrutiny as well. And a suspect classification is race, ethnicity, national origin, alienage. So a law that affects those classifications is subject to strict scrutiny. And when we're talking race, it's black or white, ethnicities, German or Italian, etc. A little more on suspect classifications under equal protection. In regards to schools, school segregation must be intentional to be invalid. In regards to alienage, federal statutes are generally valid unless they're arbitrary and unreasonable. State statutes are generally struck down because strict scrutiny applies in that instance. There is an exception for participation in government functions. As we said, strict scrutiny in substantive due process applies to a fundamental right. In equal protection, it applies to a fundamental right or a suspect classification. We mentioned also intermediate scrutiny, which is only found in equal protection, and this applies to gender issues or non-marital child is involved. And again, under equal protection, you have the rational basis test. We discussed that in substantive due process. That applies to all other classifications. Looking at equal protection and discrimination. So we've talked about fundamental rights, suspect classifications. Here we're talking about discrimination. And discrimination can be, a law can be discriminatory on its face, where it's in its language, or by its application. Now, when you're applying equal protection in the case of discrimination, there must be discriminatory intent. Disparate impact of a law is insufficient to apply equal protection standards. It's facially discriminatory if it's clear within its language that its intent is to discriminate. This gets strict scrutiny. Where it is discriminatory in its application. This may be where the law is facially neutral, doesn't have any discriminatory language, but it's applied with a discriminatory purpose. Here you have to look to the motive. If it's facially neutral but discriminatory motive, it gets strict scrutiny. Basically just apply strict scrutiny. Where it is a disparate impact, you use a lesser standard. There I would probably use a rational basis standard of review. This section was substantive due process and equal protection. Now on the exam, it's important to note the differences and apply the appropriate one. Where a fundamental right is being denied to all individuals or all groups or all parties, then it is a substantive due process issue. If it's denied for some individuals or some groups, then it is an equal protection issue. Now, there are a couple of fundamental rights unique to equal protection. So if these rights are implicated on the exam, consider your equal protection usage in answering the question. And these fundamental rights unique to equal protection are voting, travel, gerrymandering. Those are unique. On the exam, if travel and voting are implicated, due process and equal protection are likely both applicable. But if universal denial, then due process. And if group denial, then equal protection. But if it's voting and travel, more than likely both due process and equal protection. Then you have to break it down if it's universal or a separate group denial. Then under equal protection, we have non-suspect classifications. These laws are generally upheld. So you can essentially discriminate away. Non-suspect classifications are age, poverty, sexual orientation, and these receive rational basis. Sexual orientation might be changing, but as of now it's rational basis. And lastly, for this section, looking at comity. This is a privileges and immunities clause, and comity is essentially the same as full faith and credit. Full faith and credit applies to judgments of courts. Other jurisdictions have to give full faith and credit. Comity is where a state has to give equal respect or protection to the laws of citizens of the other states. Such as when I drive into Wisconsin with the Minnesota driver's license, Wisconsin would have to recognize my Minnesota driver's license. This is found in Article 4, Section 2. This is a comity clause. Citizens of each state shall be entitled to privileges and immunities of citizens in the several states. Prevents one state from discriminating against citizens of another state. and it applies to fundamental rights and essential activities. And that completes part 3 of constitutional law.